Hello?
Hi, Kim.
Hello?
How are you?
I'm stressed out. I got an appointment at 2:10. I just hitting my mark. I just choked down a lunch real quick, and I had to eat something because I didn't eat all day. So just go, go, go.
Yeah, I'm sorry. Well, we just have two things to talk about, so it doesn't have to be long. We can schedule another follow-up when you have more time for next week, okay?
So what's going on?
Two things. The first thing is that we are working on our own travel arrangements to get to court, since we have in-person court stuff coming up. And so I wanted to talk to you about both the hearing date, that's October 16th, and then also the trial date, and talk to you about transportation and you getting there for trial. But before I keep going, I wanted to tell you, you're on speaker, and JP Hill is here, and so is our paralegal Lori, and then our investigator, who's new, you haven't met him yet, but his name's Chuck, and he's here too. Say hi, Chuck.
Hey, how you doing, kid?
I've been better.
Yeah. Good. Okay, so October 16th, there will be a video option for you to call in and attend. You do have the freedom, if you want to travel there and come in person, you can show up in person at that hearing if you want to. But
Now I have a question. Somebody told me. So how will I fly if they have the date of the 28th of October for trial? How will I get out there, and where will I stay?
Well, so there's where you stay is up to you. You can stay wherever you want.
Well, I have an EBT card, and I am out here getting 100% subsidized housing. I get general relief from the county of it's like $355 a month. So
yeah.
I don't really have the means. What would I do as far as like travel and stay?
So for the hearing on the 16th, you don't have to come to that.
That's not what I'm asking about, though. I'm asking about the trial.
Okay, so for trial, we can get a court order to get the U.S. Marshal to pay for your flight to D.C. And so if that's the case, and I figured you probably would need that, then we'll get that motion turned in to start getting that ball rolling on getting it approved and getting it booked. And then as far as lodging, though, during the trial, we asked about that, and the marshal has said they will not pay for accommodations. So at this point, it looks like wherever you stay is up to you, and it's on you. But they will pay for the flight.
And how about, can you get a court order for me to fly out on the 17th as well? Or 16th?
No, because for the hearing, your presence is not required. It's just your attendance is required, but you have the option of calling in and attending the virtual version of it. We will be physically in the courtroom.
Do I have the right to be physically in the courtroom?
Yes.
And do I have the right to ask the court to make it so that I can be physically in the courtroom with a marshal's assistance?
They will not order it for the hearing. The judge will order it for the trial.
Okay, question for you. What is the Criminal Justice Act panel? What are they?
Those are attorneys that they take conflict cases. So anytime the public defender's office can't take a case, then they send the cases to the conflict panel. And then CJA is the Criminal Justice Act. It's just the act that gives the court authority to do that.
Okay, well, I saw that you received my email in which I asked you about the minute orders for 2024, and you did see that, right?
Yes.
So am I allowed to see all the minute orders? Can you forward that to me?
Yeah, so are there, I mean,
I mean, it's just 2024. We're talking like what, 9
Yeah.
months worth. We're not talking about like the whole thing.
No, I mean, I could send you all of them. There's some of the orders have written documents that the judge attaches, and I send you a lot of those. I can send you any that are available.
So when the judge, I got a question for you. When the judge made an order for me to be screened for eligibility to be represented by an attorney from the Criminal Justice Act panel, what was the disposition of that? Was I screened?
When was this? What are you talking about?
So on January 10th, right after Michael Bo Griffith removed himself from the case, there was a court order that ordered that defendant shall be screened for eligibility to be represented by an attorney from the Criminal Justice Act panel.
Okay.
What happened with that screening? What took place? Because that's a judge's order, right?
Let me, I'm pulling up the docket right now. So, typically those are orders from the court just making an affirmative order on the record that you're indigent, that you can't afford your own counsel, so that gives them the authority to access the CJA resources for an attorney, which is also us.
But you guys are you guys Criminal Justice Act panel or not?
We're not part of like the conflict panel, but the Criminal Justice Act is what gives the court authority to fund us.
So what happened with the Criminal Justice Act panel? Was that not followed through on?
Well, let me look at the order. I don't know if it says.
What was the disposition? It seems like there's no response on that and no update or anything. I don't know what. How would I find out what happened? Was I even forwarded to the Criminal Justice Act panel as per the order by the judge?
Wow, hang on. I'm trying to log into the court database to look, see what it says. Wow, I don't like pictures going so slow. What? Okay. Here, going on a little bit. Sorry, Cam, it's loading slow. Just stand by for a second.
It's fine. I've been waiting patiently for a long time. It's no problem. A few more minutes won't matter.
Close. Okay. Okay, Kim, the docket's pulled up. We're looking. Okay, here it is. Yep. Yep, here it is. I think that's just court language for indigent counsel. It includes us. Right. Outside private party. Okay, January 10th. Hereby ordered, defendants shall be screened for eligibility to be represented by an attorney from the Criminal Justice Act panel, and if defendants found eligible, that such an attorney, preferably one who is available to start trial in April, shall be appointed to represent him. Further ordered, parties shall appear for hearing. Signed by the judge.
Okay, so what happened with that eligibility determination? Did it take place?
Well, presumably, because then we got appointed.
But you're not the Criminal Justice Act panel.
We are, really. We are, it's the same funding source. It's all the same. The court may refer to us as panel because we're not local counsel. We're outside counsel also. True. It's just semantics. It has no bearing on whether or not you get SPD counsel or private attorney counsel.
Has no bearing on whether I get what? And who's speaking?
Yeah. This is Lori that's here, paralegal. Also,
so Lori's the paralegal, and she's advising me that what?
We think it's just like, it's possible that the judge is saying essentially it's counsel that's outside of their local federal public defender's office, and they had to pull from somewhere else, another place that's funded by the CJA, which is us. If you have questions about this or a problem with it, we have our hearing on the 1st. You can ask the judge there.
Yeah, I suggest it be raised. I'll probably put it up in a declaration, along with some other things. But I don't understand how the Criminal Justice Act panel would be still federal public defenders. Is Bonnie? It's your contention that federal public defenders are still in the Criminal Justice Act panel?
We are funded by the Criminal Justice Act, yes. We're not part of
the panel. I'm talking about the panel. Are you part of the panel?
I mean, functionally, yes, but we use the word panel to mean the conflict list.
Yeah, and that's what I'm referring to.
Sure, but I don't...
Are you part of the conflict list?
It's also conflicting for time. No.
You're not part of the conflict list, Bonnie?
I'm not part of, the local conflict list.
Are you part of any conflict list?
No.
Okay, no, you're not. Okay.
No, because, Kim, I'm not in that district, so they had to find other counsel outside of that district. So
but have you ever been part of a conflict panel? Or conflict list? Bonnie? No?
No. But, Kim, at this point, you need to understand that the judge clearly does not have a problem with our appointment as federal public defenders. So
I have a problem with the judge's order not being followed, especially when it's supposed to be followed as part of protocol, and evidently it wasn't followed. And, I may be slow, but I'm not dead. So it's going to take me a little time to figure things out, but I did find this, and, I'm expending a lot of time trying to figure out what went wrong here, because I was under the impression something else was going to happen, and it didn't happen. So what I'm saying to you is, if you've never been part of a conflict panel, and the Criminal Justice Act panel was ordered to have my case referred to for determination of eligibility, I'm wondering why it was just rerouted back to the Federal Public Defender's Office and not to a panel.
About your financial status, about whether you're eligible to have a lawyer appointed to you through the Criminal Justice Act, which you are.
No. Obviously, that was already determined when I got a federal public defender. It's not about but here's what I'm going to try to say to you, is that there is a distinction between federal public defenders and conflict panel attorneys. Is there not? Bonnie, is there a distinction between federal public defenders and attorneys from a conflict panel? Is there a distinction?
In the sense of how they are paid, yes. Either the court cuts the lawyer directly a check because they're on the panel and they have their own private practice, or they're employed by the SPD and they make a standard salary. So that's the only distinction.
That's the only distinction is how they're paid? Is that your position, That's the only distinction between a conflict. So a conflict panel, the only difference between a conflict panel and a federal public defender is how they're paid. There's no other reason to have a conflict panel?
No.
There's no other reason to have a conflict panel.
Listen, hey, Kim, the judge ordered us appointed. I'm not trying to take a beef with that. We got a trial in a month.
Well, you should have a beef with that because that's not representing my interest. If a conflict panel was ordered by the judge, and you're contending to me that the only difference between a conflict panel and a federal public defender attorney and a conflict panel attorney is how they're paid, I mean, that doesn't seem correct to me. I think it's inherent in the word conflict that a conflict panel serves a different purpose than just being another way to pay some attorney. I think the fact that a conflict panel is designated as conflict panel would probably denote that there is a difference there other than the way they're paid. I think that there's something more implied.
Ken, but listen, in this case, the judge already told you that he did not see there to be a conflict with the FPD's office. And so I'm just going off of what he said. There's no issue.
Well, I mean, but that was, okay, again, it was like the first time I had a chance to argue that was I was given 5 days notice or 3, I don't know, something like 3 to 5 days notice, not adequate time for me to prepare or preserve my due process. And then the second time I was given 13 days, but this was after I had a vehicle accident that totaled my vehicle. So 13 days and 5 days, that's not due process. I think the minimum would be 2 weeks or 3 weeks. I mean, the judge, when I brought that up, he went ahead and said, okay, 3 weeks till the next hearing. So, but he did dismiss it without prejudice. But, I mean, he dismissed it without prejudice, but he still dismissed it without giving me a fair shake at getting the evidence. And you didn't get the evidence to him. There's like an abundance of things that could have been put into the record that were not. And so an argument was not made to my liking, or I would think to any degree of standard for like what meets the due process criteria. So I'm just curious as to why you're acknowledging that conflict panel attorneys are different than federal public defenders, and are you still? I think you acquiesced and affirmed that there's more to it than just the way they're paid, or are you still maintaining that?
Kim, the judge said that he gave you enough time. He heard your due process argument. He heard your argument and all the issues you wanted to raise about your personal circumstances, your time to prepare for those. He heard it. He made a ruling. I understand you don't like it and you don't agree with it. That's okay. Mm-hmm. But we have to then keep forward. That's the ruling. If we want to challenge his rulings, that's for appeal. And we're not there yet. We got to get through the trial before there's an appeal. I also, as your attorney...
Well, there's not going to be an appeal if there's no appealable issues. And coincidentally, you don't seem to be putting raising any kind of appealable questions into the record. So I don't really think there would be an appeal the way you're handling it, because you're pulling your punches, to be honest.
So then listen, Kim, so then there is an appeal. It's a matter of what the appeal issues are. So in that circumstance, if you want to raise that I've been ineffective, you do that in the appeal, and you do that after trial. You're not allowed to do it yet. No one will accept it. It's not possible. You do it after. So just hold on to these things. If you want to make a list and you want to prepare for your appeal,
you can do that. Too little, too late, right? Too little, too late.
Because understand, it's not too late. It's that you're too early. Appeal is after trial, and we're not there yet. So
No. But appeal isn't just a process that is after trial. Appeal is by raising arguments that are strong, and so then if they are shot down, therefore there will be something to appeal. If you raise something that's strong, but if you don't raise any appealable issues, if they're denied, then there really won't be any grounds for an appeal.
Kim, so that's correct in part. You do have to build the record during the case to try to prepare good issues for appeal. But the appeal legal process does not start until afterwards. So
and I'm not saying the legal process of appeal starts now.
Okay. Listen, during the case, we are preparing the record for appeal. That is a huge part of our job, is preparing that, making arguments, raising arguments. The word we use is preserving them. So let us do that.
Okay, I got a question for you. What's your take on the entrapment by estoppel defense?
What do you mean? I bet it's a... Okay.
So is that a defense that you are willing to consider looking into for my case?
We have looked into it.
In what way?
That we've looked at what it is and compared it against the facts and made an analysis that it's not appropriate for us.
And how did you investigate to determine it's not appropriate for you?
Because we looked at the law and the case law and the facts of your case.
What facts in my case did you look at?
The discovery. What do you mean?
Okay, what specifically in the discovery did you look at?
All of it, Kim. All the body cameras, the videos, the police report.
All of it? I mean, because from what I understand from Bo, he said there's a minimum of 10,000 hours, and I understand there's even like 40,000 hours. So were you able to, because Bo told me to look at 10,000 hours of video, it would take a year.
Kim, we have looked at all the discovery that pertains to you.
Well, how do you know that unless you've explored it? What's entrapment by estoppel? What did you look at to determine that I had no entrapment by estoppel defense?
Kim, I want to...
Well, this is just a legal discussion. Can you answer the question or not?
No, Kim.
You cannot answer the question?
Kim, you're telling me you have, 5 more minutes for this conversation.
That's fine. This is important. I'm trying to get an answer out of you. You know? What did you view to determine that I didn't have an entrapment by estoppel defense?
The discovery that pertains to you that we've provided to you that you have not looked at yet, that is available for you to watch.
Oh, so a minimum, like a limited discovery you looked at to determine that. And how did you determine the other discovery was not relevant to an entrapment by estoppel defense?
Kim, when you say entrapment by estoppel, what do you mean? What do you think that is?
Well, for an example, Craig, who retired from my case, Craig Harbaugh, he argued to me, or made the point to me, that we should go for entrapment by estoppel defense. And he mentioned that the authority figure that I would, say gave me the impression was Donald Trump. So he saw that he said this is a strong defense for you to take. Entrapment by, now he retired, and so he's no longer on the case, but that's what direction he wanted to go in, was entrapment by estoppel, and that's documented.
Okay.
And so what I'm asking you is what you did to determine if there were any entrapment by estoppel defenses that could possibly be used for me.
So you do have to be able to point to specific authority from a person with the authority to speak on those issues.
And what authorities did you investigate to see if that was the case, that I could do that, entrapment by estoppel?
Kim, there is not anyone. There's no president. There is no other police officer. There's nobody that can give you permission and change the law immediately in that moment to allow you to move into certain barriers outside the Capitol.
I don't think that fits the definition of entrapment by estoppel, because when an authority figure does give you the impression, whether it's illegal or legal, I think just at the basics of entrapment by estoppel, it's an authority figure gave you the impression that something was legal that was not legal. That's what the defense would be for entrapment by estoppel. So it doesn't matter if it's legal or not. Oh, actually, it does matter. It would only apply to something that's illegal that you conducted yourself in because you were given by an authority figure that you had the right to do it, right? I can't hear what you're whispering.
The person who says whatever it is that you're relying on has to actually have the authority to make that thing legal for you, not give you the impression that it's legal, but actually change that for you. And that is not the case here.
I'm just telling you that how did you, I'm telling you that I want to know how you determined it was not a viable argument if Bo Harbaugh, who retired as a federal public defender, so he must have had a long, illustrious career, he thought it was a good argument. So I'm trying to figure out how you determined it was not a good argument and what due diligence you did to determine that. Because you can make a decision and you're the expert, so if you make a decision, I have to defer to the authority of your expertise, but only if you've done your due diligence. Have you done your due diligence and done any kind of investigation or digging into details? Because I can only trust your opinion that it's not a viable defense if you actually have done the work to research that. If you haven't done the work to research that, then I don't believe you can speak from a position of informed decision making. So that's why I'm asking you why you have determined that there's no such thing as entrapment by estoppel defense, in my case, when your predecessor did.
So a lot of folks have tried to raise this issue. It's an issue we looked into because people were talking about it, and I understand that. I do think President Trump gave you all the impression that it was fine to do those things.
You do think that? You do think that? Well, but so that's what you're talking about. Is a lot of folks raised the issue. A lot of folks raised the Trump issue, that it was Trump. Trump was the authority figure. Is that what you're saying?
Yes, and officers.
Okay, how about and what officers? People raised people raised the defense that officers gave the impression. Are you telling me that as well?
Will you let me talk and explain it? Okay, please stop interrupting me. If you want me to answer your question, I'm trying to answer it.
Okay, let's hear it.
Over 1,000 people have been prosecuted in these cases, okay? And everyone's charged with kind of the same 5, 6 offenses. So there's a lot of case law out there that shows a lot of the different decisions that judges from all over the D.C. Circuit have made on these issues and these defenses. So we have the benefit of kind of going towards the end after a lot of other people. There are other folks still coming and people behind us, but we have a lot of cases in front of us that we get to look at. So we looked at this issue, looked at the other opinions that the judges have issued, Judge Kelly, Judge Mehta, looked at all these other ones to see that this is consistently a defense that is rejected and denied, and it's not ever been successful, not once, because no one there actually did have that authority. But President Trump did not actually have the authority to say you can trespass, you can violate Capitol Police law. He didn't give that authority, and he doesn't even have the ability to.
No, but the law enforcement. Are you telling me that people tried to argue entrapment by estoppel by law enforcement, and which the judge said could be an argument in the prior hearing?
So some folks were talking about arguing, essentially trying to say that the movement of officers like stepping aside was somehow giving them authority to violate the law, to move into space that they can't be in.
Okay.
And that isn't correct. It's not a viable defense because their action or inaction does not change the law.
So that was denied by courts as a defense to even be entertained in a hearing, in a trial?
I mean, there's no facts to support it.
But I'm asking you this: was it before the cases went to trial? Was it denied as a defense, or did they allow it to go to the jury?
I'm not aware of that specifically being denied. I don't know that a jury has made a finding on that.
Because I thought you said the courts weren't allowing it. I thought you said that earlier. The courts weren't allowing it.
It's because people file motions in advance about it.
And the courts didn't allow it, you say?
As far as I'm aware.
So when the court doesn't allow that request to make that defense, are any of those being appealed?
Probably.
Okay. But you don't intend to pursue that defense, correct?
We do not. That's correct.
And have you actually viewed the 10,000 hours worth of video to determine that there were cases where police officers were, allowing people to come in and even escorting them? Have you done that?
So, Kim, it doesn't matter whether officers let.
It matters to me. I'm asking you, did you do that?
I'm telling you, Kim, listen, legally it does not matter.
Can you answer the question, yes or no? Did you view the 10,000 hours that Bo alleged existed? Did you view all 10,000 hours?
Kim, I have not. Because
Okay.
Here's the thing, that 10,000 hours is a database of basically everything that happened on this day.
Okay.
Every single involved. I cannot watch those. I'm not expected to watch those.
So you didn't actually do your due diligence then to come to the determination of how my defense should be enacted. You didn't really do the homework, did you?
You can take that position on it. That's fine, okay? But listen, we don't need to look at the videos to know whether the police have the authority to tell someone they can violate the law. They do not.
Well,
So,
I mean, but the point of an
videos.
entrapment by estoppel defense, it exists for a reason, and it exists not because somebody was given a lawful order or a lawful indication, and it turned out to be they argued it was lawful in the law and it was lawful when the officer or authority said it. No, entrapment by estoppel is when somebody does something that's considered after the fact unlawful, but they have a reasonable defense because they were given the impression by an authority figure that it was okay and lawful. So,
by someone who has the authority to change the law, and the police officers do not. In fact, their sole job is to enforce the law. So, the issue here is that we're not going to raise that defense. We have analyzed it. We have adequately looked at it. We cannot raise it in your case.
I don't believe you have in relation to the officers.
Kim, hang on. You need to listen.
Mm-hmm.
We are not going to raise it. And
okay, but Bonnie, you understand I don't trust you, right?
Listen, let me explain this. I'm going to tell you what you can do based on what I just told you, okay? We are not going to raise that.
I know you're not. I know you're not. I know you're not.
You are free to disagree about that strategic choice.
But you know what you're not free to do? You're not free to make that strategic choice without first becoming informed and doing your research. If you haven't done your research, then your opinion can't trump my desire because you're not coming from a place of knowledge. You didn't do the due diligence required to come to your decision.
So, Kim, if you would let me finish, I'm going to tell you that you do not have to let us represent you. You do not have to let us make these choices. You are free to represent yourself or retain.
I know, I get that. And the fact that you're allowing the prosecutor to say that he's okay with you being off my case, but he wants me to go to trial self-representing, that is something you didn't even contest. That's abhorrent to your profession. Why would you allow a person who practices law to maintain that a defendant can go to trial and should go to trial without representation?
Tim, no one's saying you should. I'm telling you.
No, the prosecutor did say that in black and white, and you didn't oppose it.
Tim, if you do not want us to be your lawyers, that is what you should do. That's your option, and that's
No,
your
the
right.
correct thing is if I do not want you to represent me, and it's not I don't want you to represent me, it's you are not representing me. You just understand the difference? You're not representing me.
Kim, you don't like what we are choosing to do. You don't get to make all the decisions. You don't have the right to make.
No, but there's a pattern and practice here, a
as long as
consistent.
you have counsel.
This latest one of entrapment by estoppel is just one of many. There's a pattern and practice here of you consistently not representing. And here's the thing. You said in the last hearing that some of my previous attorneys were federal public defenders. That's incorrect. All of them were federal public defenders. And furthermore, you didn't argue that two of them retired, one of them attacked me, and two others recused themselves after 3 weeks. So it gives the impression that I'm the problem because you're not representing me.
Kim, you don't like the way we're representing you. We are representing you. You just don't like it. And
No, you're not representing me if you're not clarifying the record. If the judge is going to sit there and say on the record that he thinks it's not going to be solved by me he thinks I'll have a problem with any attorney, and you didn't clarify that I didn't have a problem with Callie Steele. Callie Steele and I got along. Callie Steele and I ideologically are different. She's a Black Lives Matter supporter. I think that they're dangerous Marxists. But Callie Steele still was vigorously fighting for me on many issues. And she retired. There was no falling out with Callie Steele. She retired. Not my fault. Second person to retire, Craig Harborough.
The judge has ruled on this. You have lawyers for trial.
He ruled on it without you giving him insight and details.
Kim,
That's why I'm not going to go with you to trial. That's why I'm not going to. I don't even want you near me in a courtroom. Because your aura is bad. You got bad energy, bitch. I don't want to be around you. You lie to me consistently. Consistently. I don't want that aura. That's weak aura. That's weak, evil, adversarial aura. I don't want you near me. Make that clear. Put that in your notes. You are not going to be anywhere near me. Make that clear. I don't like you, but it goes beyond that. I don't trust you, and I don't believe in you. I'm disgusted by you. You're a disgrace to your profession. And the fact that you're trying to like sit here and convince me that you're part of a panel that you're not.
If you want to talk about legal issues, we can do that. You call me back, okay?